Rosbaugh versus Town of Lodi.
Good afternoon. I'm Alan Pierce from Hancock Esterbrook, counsel for appellant Town of Lodi. I'd like to reserve 3 minutes for rebuttal.
Yes.
Based on both counsel's briefing in this case, this appears to be the first case in the state of New York where treble damages have been awarded against the municipality. That ruling cannot stand. The law is clear here. The statute here, real property action.
Because they're punitive, right?
They're punitive in nature.
So this is something of a strange statute, right? It doesn't say, as the old statute, I understand, said, calculate your damages and triple it. That was 63. It says triple the stumpage value or 250 or both, right?
Yes.
So let's say you had a case with 10 trees, stumpage value is $10, it's $100. Court could triple it and be 300. In your view, that would be not permissible in this case against the municipality, right? Treble damages.
Yes, it would not be permissible.
Or it could take the 10 trees and times it by 250 and get $2,500. Would that be punitive?
Yes.
Why?
Because here, what allows treble damages is it depends on the conduct of the defendant.
No, but why would 10 times 250 be punitive? Why couldn't the judge say, okay, I'm not going to give you treble damages of $300, but I'm going to give you $2,500?
Well, here, the statute appears to, it's not discretionary. It appears to, it's not discretionary in this.
It says you can have treble damages or 250 or both, right?
Well, I believe the statute says you shall recover it unless, under subdivision 2, the defendant shows.
So you get what you get in one, but I thought one, maybe I'm reading this wrong, I thought one gave the court discretion to do treble stumpage value or 250 or both. Is that not right?
Yes, I don't think it is unusual in the sense that there are other statutes where the trebling.
Treble value of the tree timber or $250 per tree or both. So what
Yes.
if the court in that case says, I'm going to give you $2,500? I'm not going to give you treble damages, that would be punitive, but I'm going to give you $2,500 worth of damages because I'm going to do $250 per tree.
Well, the language before it, an action may be maintained against such person for treble the stumpage value of the tree or timber or 250 or both. So the statute in subdivision 1 says treble it.
Yeah, but it says instead of trebling, you can give $250 per tree.
Judge Garcia is trying to ask you, or is asking you, I think he's asked you, what if the sum of the statutory damages, 250, turned out to be greater than the treble damages?
And they give the statutory damages. Why is that punitive?
These are tiny little trees worth $10 apiece, but you're getting 250 for them. Treble would be 30. You're getting a lot more than the treble. Why wouldn't that be punitive?
Did not ask that.
I think
Well,
you did.
I read the statute, perhaps, as saying that whether it's 250 per tree or the stumpage value, under subdivision 1, it is to be trebled.
Oh, you think the 250 is to be
Oh,
trebled?
the
250 is
treble.
trebled after it's assessed?
Yes.
Have you seen any cases that deal with this? I didn't locate any.
Well-
Exactly how it's applied, I mean.
The Fourth Department had a prior case, Swenson.
It grappled with the both point, the 250,
I haven't seen a case. I didn't see a case. I don't think Mr. Hutter found, we didn't look at that. I read the statute as saying you get this or both, and you treble it. Unless the defendant on the burden shifting says, well, I thought this was my land. I thought I had an easement, which is what the town thought. They didn't prove their case, okay? So here, and it's interesting that here in this statute, there's a lot of New York statutes with treble damages. The court just recently dealt with General Business Law 349.
So just to finish up Judge Garcia's line of questioning, if it turned out that the $250, because I think you read it to say that the court could award just the 250, right or not?
The court could award 250 per tree as part of the compensatory damages.
Could it,
yes.
could it say, I'm not going to give you stumpage value at all, but just the 250?
Yes.
Okay, so then suppose the 250, suppose the trees were only worth $10 apiece. And I take it you read the statute to say the 250 would be trebled,
Yes.
right? Forget the trebling for a moment. Would the, because of the disparity between the 250 statutory damages and the actual $10 value, stumpage value of the tree, would that be punitive? Or is it the fact of trebling that makes it punitive?
Well, it's the trebling that makes it, the trebling is the issue here, and
Okay.
that's what that is
So the
punitive in
so
nature.
as vis-à-vis a municipal defendant, or a disproportion between the statutory award and the value of the tree doesn't really matter.
It
That-
doesn't.
That wouldn't make it punitive.
I'm not arguing that you have to look at whether 250 or the stumpage value is the appropriate damages, compensatory damages against the municipality. I'm not arguing
It's
that.
the fact of trebling.
Right.
Okay.
It's the fact of trebling either one or both that makes it punitive in nature.
Yeah, can
And that's
I-
because,
No, finish it, please.
that's because the statute makes it dependent. As the two dissenters in the Fourth Department said, well, if in fact it's compensatory in nature, the trebling is compensatory in nature for aesthetic and intrinsic value of the trees, which is what the majority said, and it's what Professor Hutter argues in part from the majority.
Yeah.
As the dissenter said, well, if that's the case, how come you don't get that automatically if the defendant proves that they were not acting in bad faith? Yes.
Thank you for that. Let me ask you this. It's not that anyone has raised it, it's my own curiosity, and maybe I've just missed something. I don't even understand why this applies to the municipality. If it says if any person, are you reading this, or is there somewhere in some law or in a case that person includes the municipality?
Yes, and I
Okay, thank
apologize
you.
because I
What
don't
would that be?
have it at the tip of
Oh,
my
okay.
tongue, but there are statutes that define person as including municipality.
In this?
I don't know
Because
that there's a
It
case.
seems very odd to me the way it's written.
Yes.
If any person, et cetera, et cetera, et cetera, and then says, on the land of another or on the common or other land of a city, village, town, or county. Seems kind of odd to think that you're talking about a municipality as a person, and given the way it's written.
Yes, but there are statutes, and I apologize.
Yes, no, I know there are statutes,
It
sort of
says-
general statutes in that way. As I recall, those statutes usually say something like unless one would read the language to mean other.
Right,
Right?
and
Yeah.
clearly, this statute, in many ways, was designed against logging companies.
Yes, that's why the whole
So the
history of
person
this.
includes corporations,
Yes, that's why
businesses.
well, yes, but person we usually understand to mean entity, so I can see that. But it just struck me as very odd, given the purpose of this statute is to stop, right, this
Right.
theft.
Could
Yes.
could the town
in
have
any
been sued for trespass or conversion and for damages?
Could have been. I think
And
there
that
are
wouldn't, that
cases.
wouldn't have provided the treble damage remedy, but presumably you might be able to prove the replacement value of the trees.
Right. And here, all three causes of action in the complaint were under 861.
Can I ask you another, I think you've heard from a couple of my colleagues that the statute seems strange, different than other statutes. And to me, one of the respects is that usually when punitive damages are provided for by a statute, it describes, there's a baseline, compensatory damages, whatever it might be, and then if there's a certain scienter, a willfulness element involved, then you can inflate those damages. And I think those aren't typically related to the compensatory damage. It's not generally restricted as a multiple of the compensatories. And this is kind of backwards. It sets the baseline as 3 times the stumpage value and has a reduction for a certain kind of defendant in the case, which to me is structurally unique in terms of something that you would call punitive damages, backwards even.
Well, I'm not calling them punitive. I'm calling them, in the discussion that Professor Hutter raised in his brief, that they're punitive in nature. If we look at them.
Well,
are
you're
they
saying they're punitive in effect, ultimately, right?
Yes, and-
Otherwise, you would have to pay them, because the rule is you can't assess punitive damages against a municipality.
Absolutely.
So you must be, at some level, pointing the punitive finger at this statute, right?
I am. That these are not compensatory.
And all I'm saying is, this doesn't look like any punitive damages provision I've seen before.
I talk about two sets of statutes. One, which this court is very familiar with, Judiciary Law 487, and I agree, there it uses the word willful. There are other, and I've laid out several of them in my brief, several other statutes that, like this one, don't have that willful, knowingly standard for treble damages. So New York statutes are kind of, there's a variety of when treble damages are allowed. What's interesting, in 2003, when 861 was reenacted, the legislature added the provisions about timber in the environmental conservation law that I cited in my brief. And it sets up the exact same formula for treble damages, where they seem to be presumed if there's a violation of, so it's Environmental Conservation Law 71-0703.
710703. And
Yes.
what does that relate to? What kind
It
of?
relates to timber.
It's another tree
It's a
statute?
timber statute. that
So they
makes-
do this with trees a
Makes
lot.
it makes it misdemeanor, but also provides, so in addition to other penalties, a person who violates subdivision 1 of section 9-0303 shall be liable to a civil penalty of $250 per tree or treble damages based on the stumpage value of such tree or both. It's exactly the same.
But does it have a reducer unless someone else?
Yes.
Someone acts in a certain innocent way?
Where the order or decision finds that the defendant established by clear and convincing evidence that when such defendant committed the violation, he or she had cause to believe the land was his or her own, or that she had an easement or right of way. It's exactly the same formula, exactly the same language. There's no case talking about it, but the legislature, when it did reenacted 861 in 2003, did the same thing in these two provisions in the environmental conservation law. So they decided this was the formulation they were going to use for the theft of timber. And I don't think this court needs to look at legislative history, and I'll stop because I know but the legislative history here makes it very clear. This 2003 bill was a comprehensive bill, and it was designed to punish and create a penalty for people who stole trees or took them improperly, and to deter conduct, the traditional hallmarks of a punitive in nature penalty.
Thank you.
Good afternoon, may it please the court. Judge Garcia, in response to your, excuse me, I have to fix this sound. I have it too loud. You can't treble damage $250 per tree. The compensatory scheme that's clear in 861-1 that we're dealing with, and forget about the environmental conservation, that's another beast, totally different language, and we're not dealing with that. 861 says, here's the compensation package. Stumpage value, trebled stumpage value, or $250 per tree, or both.
What do you do?
The only thing, I'm sorry, the only thing you would treble then would be stumpage value, and that's it. And that's what this case is all about, is an award of stumpage value which is trebled. Is that punitive? We're not looking at an award of damages that are being trebled. It's a very simple compensation part. Yes, Your Honor, I'm sorry.
I was just going to ask you what you do about B, because B says for a good faith, whatever you want to call them, logger, it's 1x stumpage value, and otherwise it's 3x. So how is that not punitive? Or are you compensating the good faith owner for 1/3 of the value?
I'll use the language that Judge Troutman used in Hobich about the careful balancing. What the legislature obviously did here is that we have a problem of economic loss, economic harm.
But just,
Yeah.
is the good faith, is the owner whose trees are taken in good faith getting 1/3 of the value?
He's getting in a good faith, he's just getting stumpage value. That's it.
So in bad faith, you're getting 3x. And what is that multiplier tethered to if not the bad faith? Which seems to me like it sounds in something punitive.
It sounds like it is something punitive, but it's part of the compensation package.
Well, what is it compensating for if it's not penalizing
This is
bad faith?
This is the legislature's rough way of figuring out how do we value the property owner's loss.
But the loss seems to me, the loss is going to be the same if I'm the owner. Doesn't matter to me whether the tree is taken in good faith or bad faith. I lose the tree, the value is what it is. But it seems to me under the scheme, given the two subdivisions, that what I'm going to get turns solely on the good faith or bad faith of the person that cut it down. Is there some other metric that's at play?
What the legislature did in that situation, Your Honor, is simply, if you've acted in good faith, we really want to leave you alone, and we'll penalize then the property owner. The property owner then to sacrifice the property owner for the benefit of the good
Saying
faith.
the compensation of stumpage value penalizes a property owner?
No, I'm saying is that if they lose that, what I'm getting at is that, and I think it goes back to, I start to explain this. 861 initially had stumpage value treble. That was it. That was, excuse me, just treble damage, just simply that. That had been the law since 1803. And finally, then in 2003, and this is where the legislative history is so important. That's why I spent a lot of time in my brief going through the bill jacket, in that the legislature and Senator Little's, we need to appropriately reflect economic harm.
Counsel, do you, if it is in fact punitive, if one were to find that it is punitive, can it be imposed on the municipality?
No. No, I don't know what my adversary did below, what my counsel below did, but I certainly concede that, Your Honor.
But counsel, I'm sorry, here, do you know of any other instance where compensatory damages are reduced because of the good faith of the defendant?
No, Your Honor. No. And again, getting back to Judge Halligan, you raised a question about a lot of case law. The one case that's in my brief, Halstead versus Fournier, which actually I represented the defendant in that case, I made the argument that there was really no discretion as to what must be done. And the third department, and I think looking at it correctly, said, as I said to Judge Garcia, these are the alternatives, and that's it. You can't go beyond that. So I think there is sufficient case law, again, that's focusing on the compensation package. Now, what was troubling, I think, the legislature, and again, this is where I think here reasonable people can differ. They're trying to figure out, how do we compensate the homeowner? How do we compensate the Rosbaughs who's had their trees destroyed?
Do you agree with Mr. Pierce that your clients could have sued for trespass or for conversion and recovered the replacement value of the trees?
Yes, Your Honor. Certainly, this is a statutory cause of action. The
Right, so
Plaintiffs' Counsel is decided not to pursue common law, which would have given punitive damages.
Against the municipality?
Oh, no, it's not against the municipality, but at least on surface. Common law trespass is still a valid cause of action generally for trespass. No one does it because, again, first you need the scienter element, and again, punitive damages in New York, of course, is so difficult. So all these actions now are really RP APL 861.
You mentioned the legislative history, and I'm looking at the bill jacket from the Department of Environmental Conservation, and it says Current penalties are not high enough to deter the illegal taking of timber from state or private lands. This legislation, by increasing the penalties to allow for treble the stumpage value, will provide for greater deterrence for the knowing offender. That sounds very much like punitive in nature.
Again, I'll certainly concede there is some punitive effect. The key here is primarily, but you go back also in that bill jacket, Your Honor, with Senator Little, Assemblyman Parents, is that we're concerned about appropriate economic harm.
But can those two things coexist? Can you actually say that the true value of the tree is triple the stumpage value, but there's a punitive element to it as well? I mean, those
I
seem
think that, yes.
impossible to reconcile.
The punitive element cannot destroy the compensatory part. It is clear in that regard that this is primarily compensation. And I think in that respect.
How is it clear when the distinction, when the difference between 1x and 3x turns on the good faith or bad faith of the person that cuts down the trees?
That was, I think there, what we're quibbling over now is how the legislature drew the balance.
No, I guess what I'm trying to ask, maybe I'm not doing it very clearly, is the only point of distinction I see, and I thought you agreed, but maybe you didn't, between whether I get 1x or 3x if I'm the owner, is whether the person that cut it down acted in good faith or bad faith. Okay.
I fully agree.
Okay, and so that seems to me to have nothing to do with the actual value of what got cut down. In fact, that actual value, the 1x stumpage value, seems like that's full compensation. So I'm just trying to understand how, if what makes the difference between 1x and 3x is the conduct of the person that cuts it down, how that's not primarily punitive.
There is nothing in the legislative history about that point.
About what? I'm just talking about the text of the statute.
I realize that. Again, this is what the legislature, what they came up with.
Well, they may have, but
like
they may have come up with a punitive
the punitive was taken care of by penal law, by allowing the DAs to prosecute, ENCON to prosecute.
But surely damages can be punitive. It need not be only something set forth in the penal law, I think, no?
Well, if you're asking, is there a separate issue here as to whether or not I could pursue
No, I was asking whether or not the fact that it's set forth in this statute as opposed to in the penal law is dispositive of whether it's punitive or not.
No.
I would think no. Okay.
No, not at all.
I mean, in any event,
Counsel, I think really it's very difficult to appreciate fully this argument you're making, because it would make sense to me if 861.1 was written, may maintain against such a person for treble the stumpage value, which you say treble only applies to that, of the tree or timber, and $250. And then if section 2 would say for the person who acts in good faith, you only get, right, you can only get the treble of the stumpage value, because then it would be obvious that one is punitive and one
I'm
is
not sure, I don't think it's.
And the stumpage value, treble the stumpage value would be about compensation.
Yeah, same thing with just, if you're looking at it with Judge Halligan.
But that's my point, that I understand your argument to be, look, the legislature has identified this as compensation, and they've balanced off the good actor, the bad actor, but it's still compensation. And all I'm saying is, that argument would resonate, would, I think, be more compelling if it was written to reflect that choice. But it isn't written to reflect that choice.
If you phrase the question the way you did, more compellingly, I fully agree. But this is what the legislature wrote. They decided at this point that, gee, if you acted in good faith, just pay. We're not going to give the homeowner the full value.
so the only way to salvage this statute by approaching it that way is to undercompensate the property owner for the full value of what they lost.
I think that's
But
really the whole
but
problem,
that's why
Your Honor.
that's why I was asking about trespass and conversion, let's say conversion particularly. Because if the homeowner could sue for the full value through conversion, why would they ever resort to this statute?
Because they have the scienter aspect.
For conversion?
I think so. Common law trespass.
I guess we're
But I get-
stumped because we can't really
Is it
figure
time
out.
now to- I'm ready to recite Joyce Kilmer if you want.
I mean, honestly, when the intent of an actor is in play, it's punitive in nature, and we can't point to anything else that says otherwise. So no matter what the legislature has called it, and they want to call it compensatory, but if it looks like a duck and it quacks like a duck, then it's punitive.
Well, in response to your question, Your Honor, yes, punitive goes on conduct. But when you're tripling stumpage value, you're not tripling conduct. You're not based on conduct. It's based upon the economic harm. And I think that goes back to what I was trying to get at, and I think with Judge Canataro, when I went through the legislative history. The idea back in the turn of the century is that, what's a tree worth? And so they came up with this stumpage, this trebling damages, just trebling damages. And it's fascinating that if you look at the state, I have in my brief, state of Vermont, even Oregon. Oregon adopted their statute based upon the Field Code, which carried over that 1803. And they specifically say the reason why we're going with this is that how do you value a tree? This idea about trebling is probably the best way to figure out compensation.
That's the Joyce Kilmer argument. Trees are beautiful and pleasing to the eye, and they're...
But,
Yes,
but
if I
since
can
you-
rely on that, I'll rest.
but since you read 861.1 to only treble the stumpage, as opposed to what counsel reads it as both the stumpage and the $250 per tree, you don't necessarily get that as compensation. You get $250 for tree, possibly.
Sure, and as Judge Garcia was saying, I may be better off. And that's the other thing which I think negates any punitive
But that's
aspect.
all I'm saying is that's for the judge to decide. So I'm not really clear again on this argument about the compensatory package.
What you're looking at, this is again, the legislature's figuring out how do we compensate? And they figure the best package would be stumpage value, first time we have stumpage value. But they're also recognizing is that stumpage value with the factors is kind of vague, it's kind of ambiguous. Even if we get a jury coming back with an amount, it may not be sufficient. So they erred on the side of, maybe this is the way of responding to what Judge Halligan was getting at, they erred on the side of, we will give treble.
But only if you have bad intent.
Yes. But again, that's
All
going
I'm
again,
saying
it's
is that-
based upon, though, Judge, it's based upon it's based upon the stumpage value, economic loss. It's not necessarily based upon that conduct. That conduct goes separately with under two.
All I'm saying is you don't necessarily, I'm over here.
Okay, I'm
All
sorry.
I'm saying, that's okay. Because you're saying you don't treble the $250 per tree. You're not necessarily getting the treble on the stumpage value. And nothing in 861.1 is connected to the actual loss, right? In that way, other than the stumpage value, just pure stumpage value in provision 3, which helps understand provision 2. If it's the good faith actor, or I shouldn't say good faith, the person who didn't intentionally seek to steal your trees, right, or cut down your trees or otherwise, they're just going to have to pay for the actual cost in some
Yes.
sense, right?
And again, you may question the legislature wisdom on that. That's not the role of the
I'm not
court.
questioning any wisdom. I'm not doing that at all. I'm just saying in terms of the way 1, 2, and 3 are written, your argument, especially since you're saying treble only applies to the stumpage value, it's very hard to find a path to your interpretation of this statute, given the way these 3 provisions are written. I understand, of course, the argument you're making.
No, I understand your position, Your Honor. I just respectfully would disagree with that. Of
course.
But again, just for figuring out, my time is up. Getting back to Judge Garcia, this is a beast of a statute. It was a legislative compromise, and again, digging into that bill jacket, they were concerned about economic harm. How do we best compensate for economic harm? And to do that, they threw in this aspect now of trebling stumpage value. Again, reasonable people may differ on that. That's obviously what the legislature did. And they're really going back to the 1803 roots. Unless there are further questions, I'll rest, Your Honor.
Thank you.
Yeah.
There are three things I'd like to say.
I was
First-
afraid you were going to say there were three branches to your argument.
No. Economic harm. That's not what the appellate division majority based this decision on. They said it's the intrinsic and aesthetic value, and I'm a tree hugger, I love trees, but that's not economic harm. Not at all. And here, I think.
But Counsel, would you agree that when this statute was drafted, the only thing they really could have been thinking about was economic harm? And I mean that in the sense that this statement by the appellate division that part of the tree's value is its environmental, historical, and aesthetic quality. I don't feel like that was in the mind of the legislature when it was drafted. At this time, trees were commodities. The value of the tree was the value of the wood in the tree, and the value of a horse or a dog was in the value of whatever you could make from them, not the love or the affection or any of those things. So I wonder if you would agree that your adversary's explanation of what the value is just doesn't jibe with what the appellate division says the value is.
I don't think it does. I don't think it does. And the legislative history, to the extent you want to look at it, would not jive with that.
Well, what is all of the language in the legislative history and the focus on forestry and promoting forestry? I mean, it may not be about how lovely is a tree, but it's certainly beyond the cost of timber wood.
Yeah. They say the enactment, and this is from plaintiff's brief, the comprehensive bill in 2003 was part of a comprehensive bill intended to deter the illegal taking of trees and timber, compensate owners. The bill jacket says, we want to better enable public and private landowners to discourage timber theft by providing for
So
penalty.
the deter, is that the punitive aspect as opposed to compensating for economic?
Both deterring, and they talk about penalty levels and sufficient disincentives. Language talking about stopping illegal taking and penal in nature. The second thing is that I wanted to say was, we've talked about various values here. Ballpark numbers, they had an expert witness, about $50,000 stumpage value. Got trebled to $150,000 for these trees. Now, when you put it in those kind of numbers that are in this case, that's very punitive. And the last thing I think that I want to say is, you can look at like the case, Real Property Action and Proceedings Law 853. There might be four things. 853, it's in the same article as 861, and there's a First Department case that said those treble damages are punitive in nature. Not you, but the First Department said so, the trial court did. And the last thing is, these other states' statutes, you don't need to get there. But I think I've shown in the reply brief that generally speaking, all the other states who have timber statutes with treble damages patterned on New York statute all find, like you did in Hobish, that you can't have both treble and punitive because the treble is punitive
Yes,
in nature.
at the time of the enactment of the statute, I know there have been amendments. Was there some significant theft by mistake, sort of the person who did not have an interest in actually stealing something? In other words, provision 2, was there a lot of that going on, if I could put it that way?
In this case, Your Honor?
No, not in this case, not in
Oh.
this case. I'm saying as a
Well,
general matter, in terms of what
apparently-
the legislature was concerned with.
Everything about this statute dating back to the early 1800s would suggest that apparently there was a fair amount of theft of trees and timber taking.
The way
taking
boundaries were
place.
drawn, or the
Yeah.
way title was passed? Okay, okay.
Yeah. So,
Thank you.
and here, I would just ask, I'd conclude by saying, I ask you to modify the order appealed from, remand to Supreme Court for the court to delete the provision in the judgment allowing, or providing for treble damages. Thank you.
Thank you.